Hi, I'm Kimberly Rigo from Special Education Advocacy. And today I'd like to talk to you about your IEP and how to work on it effectively with your special education department. I refer to this as the escalation process. Before we get sort of into the nitty-gritty, I want to share a quote with you that I heard at a Rights Law presentation. I'm not 100% certain who said this quote, but I think it may have actually been Attorney Wright himself, and it goes like this. Special education is like a marriage from which there is no divorce. A little on the disturbing side, but actually pretty true. And I think it's a really important thought to have when you frame the way you enter into any kind of a conversation or any kind of a debate about the services your child is or isn't getting in their IEP. The least amount of adversarial interaction you can have, the better. Remember that the person across the table from you has the power to give you what you need. So it's never going to be in your interest to scream or yell or, be really challenging. So let's move on, and I'll talk a little more about the details of working inside of special ed. Okay, there's a few things that I think you really need to know before you go in and try to negotiate changes or additions, deletions, whatever your issue may be. The first one is it's really important that you understand that, like any organization, schools have a hierarchy, and you need to go through them in their proper order. You don't want to go jumping from the bottom of the pile straight up to the top. So the way it works in schools, and there's some variation from place to place, but generally speaking, the hierarchy starts with your teachers and your specialists. So these are the people every day in the class with your kid. They're doing the ABCs, they're doing speech and language, they're doing behavioral support. That is ground zero. The next person up would be, and they have many names in many different places, but liaisons, facilitators, case managers. So sometimes these are educators and sometimes these are administrators, but they are always the person who's been tasked with following your case, providing documentation of what was discussed, and communicating changes to your IEP document. So they're pretty important. Usually they have quite a lot of conversation with the people that are interacting with your children, who are level 1 in the hierarchy, your teachers and your specialist. After the liaisons, facilitators, and case managers, I would like you to consider the principal of your school. Even though they're not technically part of special education, every principal is responsible for all the resources inside of their building, of which special education is one. So they, in an umbrella sort of way, are responsible for the special educators and all of the people who deliver specialized services, people in integrated classrooms, and I always do think it's a good idea to include them as you come up through the hierarchy, depending on how many people need to be included in your circle when you have this conversation. After you come through the principal, if you find you still need to go further up the ladder, you would probably be looking for somebody like a building coordinator, or there are a lot of different names, but very frequently this is an administrator who is tasked with overseeing several case managers and everybody that falls in their grouping. Above them is the assistant special education director, and above that would be the director of special education. Above the director is the superintendent of schools, and this is one of those ones that people sometimes tell me, oh, I tried to talk to the superintendent, and the superintendent said they don't get involved with special ed. Sometimes that simply means they don't want to get involved with your special education issues because you didn't come up through the system. But the truth is that not always, but frequently, they hired the special education director, which does put it directly in their purview. HIPAA, mental health parity, privacy laws, all of which are very important, do not prevent a superintendent of schools from becoming involved in negotiating issues if there's a problem or there's friction between, operationally, the way things are being done. The last stop on the hierarchy list is the Department of Elementary and Secondary Education. So this is the Board of Ed, as many of you know it, and they are responsible for monitoring compliance to IEPs, quality of service delivery, timelines. They frequently will issue advisories directing administrators how to implement sort of gray areas, and they're pretty important, and they are at the very top of the stack. So the next thing that you need to know is you need to understand, as the school understands, what a resource is. So a resource in special education is anything that is needed to educate your child. It's a teacher, it's the textbooks, it's the curriculum, it's the training, it's the programming in summer. A resource is anything, up to and including the bodies that, walk around in the cafeteria, but which are needed to support your child, and they all cost money. So that's pretty important to note. They all cost money. When you request a resource, you're asking for what your child needs. On the other side of the table, when you request a resource, they may understand that it would be helpful to your child, but they have a certain amount of resources that they have to allocate. And it is a case of the worst case scenario or the loudest will get the resource. Why would a district refuse you a resource? There are a couple different reasons. Usually, the reason that you don't get a resource, if you truly need it to support your child, is you haven't presented enough evidence. We'll talk a little bit more about how you get together evidence that you need things, but the way to convince them that you need it, if they're not inclined to say yes, is not to get angry. It's to get more information and try to convince them. Okay, the third thing that I think every parent needs to know at the beginning of the process, when things are not going well, is you need to make sure that you really understand the initial evaluation that was done for your child. You want to know who requested that evaluation. Was it you? Was it the school? And what led up to that request? Was the child failing? Were there behavioral problems? You really want to have a good understanding of the process that got you to the IEP. So assuming that you've done that, I would suggest that you should know the qualifications of the evaluator, whether it was done privately or in the school. If it was done by the school, you have the right to request their credentials and understand the testing methodology that was used and where it was done. Really, any piece of information about it should be available to you, and you should have it. The other thing you want to know about the evaluation is were the panels completed at best practice standards. And when I say that, what I mean is if you were to go to Children's Hospital Boston, I'm just going to use that as an example because they're a high quality facility, and get that same testing done, and then you put one testing against the other, with the environment, the qualifications, the methodology of inquiry, and the way they coordinate the information to make recommendations, were all of those of very high caliber, and were they done the way that is considered best, most effective? The last thing that I think you really need to understand, before you decide to start kicking things up the ladder, is you want to understand, are there recommendations from the testing? If there are no recommendations from the testing, then it's kind of up for debate what should be done about the results. So it's a pretty important thing. You should come away from any good evaluation with a very clear set of recommendations. And are those recommendations currently implemented into your IEP? This is super important. I have seen a lot of evaluations, even ones that were done privately, where you got this great eval, then you got these great recommendations, and then it went nowhere. They made no changes to the IEP, and that was kind of the point, was if the evaluator said that this child really needs to be supported in a way, that gives them visual access to the teacher, and nobody ever changed their seat, then you've wasted the evaluation. So that's an overly simplistic way of explaining it, but I think you get the point. And lastly, when you get recommendations, you should ask a lot of questions if you have the opportunity to speak with the evaluator. It's helpful if those recommendations are as specific as they possibly can be. And some examples of things, ways that you can make things very specific are, I actually would like you to have an evaluator say how many hours per time a week of a certain service or support, administered or overseen by who. So is it going to be done by a paraprofessional, or will the speech and language pathologist be doing it? Very important questions to ask, and they should be clearly written into your IEP. What team members are responsible for implementation? So can it just say a special ed teacher, or is it going to be the special ed teacher who works with your child every single day? As specific as possible in every single opportunity. The last thing, and this is kind of its own category, but it's just, I want to put it on your radar, is you want to make sure the recommendations make a point of explaining their expectation for progress. So if the child is given 30 minutes a week of speech and language pathology, I expect them to progress and be able to do on-grade classwork. So that would be a good example of a very specific expectation that goes along with the recommendation. And it gives you a point of reference if things don't go well. So that one is pretty important. Okay, so the next group of things that I want to talk about they're kind of, the first part was, what do I think you need to know before you kind of get in and have a big conversation about changes or, problems. Now I want to talk about what I think you need to do. You personally should try to understand these things so that you can have an informed conversation with the people that are handling your child's special education. You need to make sure that you have a diagnosis or an understanding of the profile that creates the challenges that your child has. You could do that through school testing that may have come to you through private or outside evaluations, or some combination of both. And you want to use those evaluations as your opportunity to make sure that you really do understand best practice and what your options may be if you have options. You need to make sure that you have already attended a basic rights presentation. So we're kind of walking through operationally, how do you maneuver through the system, but it's super important that when you discover you need special education, you actually go and attend one of these presentations. They're all over the place, they're free, and they are your basic entry-level insight into what laws protect you and how you can use them to effectively support your child. I would like to talk a little bit about effective progress. Effective progress is a legal term that defines how much progress your child is making. And it could be a whole presentation unto itself, so I'm not going to go too deeply into this. But you need to understand what effective progress should look like. And this goes back to your recommendation and expectation from your expert. What does effective progress look like if they get the supports that were recommended? And you need to make sure that your IEP, that you understand in your IEP, what will that look like? Because if you don't know what it would look like, when it doesn't happen, you can't identify it. And then I want you to be very sure that when you go into your IEP meeting, you've read through the current levels of performance. Do they paint an accurate picture of your child? Can I read the current levels of performance along with the parent visions and concerns, and do I understand who this kid is, what his challenges are, what her problems are? I should be able to pick up this IP and drop it off in California, and that team should be able to implement this based on what's in there. So if you don't feel like that is an accurate picture, you need to make corrections to that. That's something that you need to have a conversation about with your team. Vision and concern statements, I just mentioned those. These get overlooked a lot. These are your two pieces of parental input where you say what worries you about what's going on with your kid, and also what worries you that isn't being done, or that you think isn't being done well, or that you think could be done better. That would be your concern statement. You shouldn't shy away from this. You should be super specific, up to and including, I am concerned that Johnny isn't getting enough speech and language. Just, to make effective progress. That's a thing that you should write in there if it's true. The vision statement is a little different. The vision statement is, in your dreamscape, what you really want for your child. I want him to go to college. I want him to have a job and get married. This is sort of long-term, what you're working towards. And it's okay if other people think that your vision is a little on the high side for your kids' abilities. I have known a lot of children who have really, really blown away people's expectations and done far more because they had parents that really believed it and were willing to work to make it happen. So, and then the last thing is I just want to restate what we talked about in the last slide, which is the chain of command. You need to understand that this is a process, and you can't jump the chain of command. You need to start with your teachers, and then you need to increasingly bring people into the conversation, escalate as it becomes necessary. When you feel that you've exhausted the conversation with the teachers, then we would be talking to facilitators. And when we're done, facilitators don't seem to be getting the job done, then we go up to the next level. So I don't want you to call your superintendent because, you didn't get your logbook. That's not an appropriate use of the chain of command. That's jumping over like 6 different levels. And really what that will do is it will make people not want to work with you. So something to be really aware of. You want to try to work with the people, at the bottom first, so that you can build trust. You need to have a relationship with them. Those are the people you're going to see every day. And if you think of your own job in your own life, would you like it if somebody went to your boss without ever coming to you to make a complaint? You probably wouldn't like that. So give everybody an opportunity to do their job before you come up. Okay, the next thing that I think is really important is your paper trail. This is how you get heard in special education. We have an expression among advocates, you may or may not have heard that, and which is, that if it isn't in writing, it never happened. And there is nowhere you will find this to be truer than in special education. Having said that, I'm going to suggest that you save absolutely everything, and I mean everything. I want you to save homework. I want you to save mail from the district, including the envelope. If the date it was sent and the date you received it, like the date at the top of the letter, if they don't match, I want you to save those. I want you to save communication logs. Please save the document that has a little N1 at the bottom. N1 document is a summary document from the district explaining what was discussed, if there were any disagreements, how they were resolved. They're very important. And you also have the right to reject an N1. You are supposed to, at the end of any meeting, they're supposed to come out and present you with a summary draft that is the written, sometimes typed, just the bullet points usually of everything that happened in the meeting. Please don't just sign this. I really, really want you to read this, even if you feel uncomfortable. I want you to take a minute. I want you to read that. If there was something important that happened in your meeting and it's not in your N1 summary draft, then it's not going to be in your printed N1. And it's a lot harder to get an N1 changed than to say, I'm just going to write this on here right now on my summary draft before I sign it. They usually are happy to oblige because they're trying to get the meeting over with. You know, the meeting is done and they just want to get out of the room. But you have a lot of power at this point to make sure that there's documentation, and I strongly suggest you take advantage of that. Let's see. Mismatched dates. This happens a lot, and I mentioned this briefly already, but sometimes innocently and sometimes less so, things don't get out on time. There are legal dates of compliance that the district is required. 5 days to respond to a request for an evaluation, 30 days to complete an evaluation, 10 days from the completion to a reconvene meeting. These are legally mandated timelines, and the district can actually get cited if they're not compliant. So sometimes the date at the top of the letter or the response or whatever can be several days, maybe a week apart from the date that it was actually mailed. And if this happens, I'm going to suggest you save it. I'm not usually interested in banging districts over the head with compliance unless it's really egregious. But should you get to the point where just nothing works and everything falls apart, it does paint a convincing picture of somebody that was kind of not keeping pace with what was going on, and that can be useful to you in the future. So, okay, rejections. There are a couple different ways that you can reject things. You can fully reject something, a whole rejection, or you can partially reject them. You should never reject an entirely new IEP. I'm sure you've been told this if you attended a basic rights presentation. And the partially reject language is you want to reject the omission of X, but accept all the services and the placement as written. You can reject anything. You can reject an evaluation, you can reject a recommendation, a placement, transport, qualifications. As I already mentioned, you can reject the omission of something, but that is the language that you want to use. Reject the omission of, if you wanted something and did not get it. Something that people often don't understand is sometimes you sign an IEP and then at some point, or maybe immediately after you sign, you no longer think that that's appropriate. You have the right to rescind your signature. You need to write a letter. It needs to be, formally stated. Address it to your case manager that, you are formally rescinding your signature on the IP with the dates that are usually in the upper right-hand corner of the document. And at that point, your child's services would revert back to the former IEP. You don't want to rescind your signature if it's your first IEP, sort of the same thing as a brand new IEP and a full rejection, because then if you rescind your signature, there are no services in place. The last thing that I want to talk about in the sort of scope of rejections is called stay put. Stay put is a temporary right to maintain support or placement or services while an IEP or an IEP services in dispute. When you invoke stay put, you revert to the former IEP or the former service, depending on how you describe it. It will stop the removal of that service. So you're stay putting the former service so that the district cannot remove it while you have ongoing conversation. It is not intended to be a permanent solution. There is supposed to be a meeting about they say no, you say yes, and some kind of resolution. But this is a temporary solution when you reach an impasse. It's really important to mention that stay put does not apply to a physical placement. You can't stay put your child's placement in a certain building say the building only goes up to 6th grade and you don't want your child to leave that building, but they haven't got 7th grade there. You can't stay put that placement, unfortunately. That's called the brick and mortar exception, so it's important to remember. Okay, this is a really, really big part of getting through a conversation with special ed about services or supports that you don't feel are sufficient or appropriate evaluations. At the top of the list, pretty much everybody should have a pediatric neuropsychological evaluation done by a highly qualified psychologist or preferably a neuropsychologist. They can give you a lot of different information about a lot of different disabilities, but specifically a neuropsychological evaluation is informed by an understanding of the educational process. So they're not just going to look at what's going on with the kid, they're going to also look at how does this disability affect the way they learn, and their recommendations should reflect how can we adapt the learning environment so that this child can learn around their challenges. They can provide you with information about all kinds of disabilities, sensory, trauma, alternative communication, assistive technology, medical situations, or medically involved kids. And they should also have some input into vocational and transitional services. So, above the basic OT, PT, speech and language, there's a lot of information that should color the recommendations from a really good neuropsychological evaluation. I really think it's important that this evaluation includes an observation, or at least that there's the possibility that it could include an observation. Very frequently, I hear parents tell me, that they had a costly neuropsychological evaluation done, and that the recommendations, were for whatever, and then the school will say, well, we disagree, and that neuropsychologist has never seen what we're doing here. Okay, so how do you solve that? You need your expert, your neuropsychological expert, to be able to go into the school if that comes up and defend their recommendations. So that's a question that you need to ask in advance if you're going to look into doing this privately. I would really strongly urge you to find somebody who has the ability to go into the school for you. Not all evaluators would do this, and especially the big campus hospitals, which is surprising because they're considered to be so top-notch, but it's very rare for them to come out of their silo and into the school system, which makes it challenging to use their recommendations sometimes. I think that a good neuropsychological evaluation needs to include a couple things, more than a couple. You want a concrete, best practice-driven recommendation for supports that describe the qualifications necessary of the staff. You want to know how often and what the duration of services are. oversight and who is handling program design if it's not that person actually delivering the service. How frequently are they talking? You want recommendations for placement that are super specific. Class size, staffing ratios, program focus like social emotional or OT, sensory. And then you want to describe the appropriateness of an inclusive setting. It is not appropriate for every child. It's kind of the big popular thing, everyone must be included all the time. There are actually kids for whom inclusion is a very stressful and not supportive environment. And if your child is one of those, you definitely want your neuropsychological evaluation to reflect that. Does your child need a substantially separate placement? Some kids really do need that. And, so this is one of the things you would want to have covered. Again, I can't emphasize enough how important it is that your neuropsychologist describes the expected outcome for your child if provided with the recommended levels of support. This is really, really important because if your child fails to progress, then you can go back and say, well, that's because you didn't put in the right supports that were recommended. Or if they put in the right levels of supports, what else can we do? It gives you a baseline from which to come up the ladder through all the different people that can help you to influence what happens to your IEP. Neuropsychological evaluation should be repeated every 24 months. And it's very helpful if your neuropsychologist follows your child through their academic career. Sometimes, maybe because somebody couldn't quite put a name on what their child had, or because it didn't help them get what they needed from their IEP, people will bounce around, and this is a really bad idea. Go to a really good, high-quality neuropsychologist, and then have them follow you. Because if it ever gets really contentious, this person is truly an expert on your child. Expert with a history as long as the educators. And that can really make or break the impact of their recommendations and their reporting about what's going on with your kid. Okay, so what happens when you've done all this stuff? You've called your meeting, you went to basic rights, you wrote your letters formally, you saved all your records, you've got an expert following your kid, and the expert has gone into the school, and still, you cannot get it done. You can't get the appropriate services, you can't get the placement, it's not working. So usually the next step is you would hire a professional advocate. So a lot of people ask, where do I find one? I'm going to suggest a few places. SPAN, which is an advocacy sort of clearinghouse. They certify and track advocates in Massachusetts. Mass Advocates for Children, which is a legal advocacy organization. They are involved in legislation. They do parent outreach. They work in school systems. They can refer you to a good advocate. The Federation for Children with Special Needs, that would be an appropriate place to call and ask. And all of these numbers will be provided at the end of the presentation. AANE, which used to be the Autism and Asperger's group. They've had a name change, and I'm sorry. Disability Law Foundation, Children's Disability Law Foundation, and your local CPAC. If you haven't been to your local CPAC, you really should go. These are people that are experiencing the same kind of problems you are within your district. And often if you find there's a collection of people with the same problem, there can be power in a collective voice. The qualifications of an advocate. I'm going to suggest that you try to find an advocate by getting a referral from a parent who has used them. Everybody has to start somewhere, but if somebody can say, I am using or I have used and I was very happy, that's definitely a step in the right direction. You want to make sure your advocate can demonstrate an understanding of the Massachusetts laws or whatever state you are in, and how are they implemented in special education. You want to make sure your advocate has a collection of resources ready to share with you. Um, you know, do they have a list of vetted neuropsychologists? Do they know where you can go to get a reading specialist if your child wants to get tutoring outside and you're going to pay for it? Um, do they know where you can go for social skills classes? Do they understand the different schools and what's available in your area for your child's disability? That's something that a good advocate should have ready to go pretty easily. They should be, in Massachusetts, they should have a minimum of an advocacy training certificate. And I would like to share with you that that is really just an entry-level education. But they should definitely have that. If they don't have any kind of background training for advocating for parents and families, I would be a little suspicious. Unless they're an attorney, which is different, but usually you wouldn't refer to your attorney as an advocate, although they certainly are. I want to be very clear that you shouldn't hire an advocate who doesn't provide you with a contract that very clearly defines what they will provide and what they're going to charge you for it and how they will be charging you for it. Are they charging you if they do 1 minute into the hour? Are you paying for the hour? Are they charging you in a 10-minute block? And they should be able to invoice you so that you can see that really clearly. I've heard some stories about people who take a large sum of money up front and then it's kind of not really understood how it's being spent. And I don't think that's a good idea. So I would be very clear and ask how the services will be billed. I also think that the advocate should want to meet your kid. I think that it's really important that anybody you retain to represent your family see that person, not just the list of challenges. So I personally think that's very important. I know that's not something that every single advocate does, but I do think that that's pretty important. What will an advocate ask you for? Before they can get started, a good one is going to ask you for records back at least 24 months so that they can get a good picture of what's been going on and what the school has done, what the school hasn't done, what you have done, what you haven't done, as well as to get a really functional understanding of the challenges that your child is operating with at school. They should be willing to draft your letters, review your IEPs, and help you or completely write your rejection letters. They should attend your team meetings if you request it, maintain and create your records going forward from the point where you retain them, attend mediations, should you have one, and they should be able to tell you when you've reached the point where they can't be impactful. If you need to move on to legal counsel or, really that's it. If they need to push you further along, they should be willing to say that instead of sort of staying at the meeting and doing the same thing over and over again without result. The cost of an advocate there's a pretty huge range here, huge actually. In Massachusetts, I did a quick survey recently, and the range was anywhere from $45 to $275 an hour. That's a range. Just for your own information, there are pretty solid special education attorneys for $275 an hour. So if somebody quotes you that much money, it would give me pause. I would want to give it some thought. Frequently, an advocate will take a binder, somewhere from $300 to $1,500. That sort of seals the contract, and they work against that money while they do your record review and get involved in your case. Some advocates do offer sliding scale for families that have financial hardship, and you should never be embarrassed. If you're in that situation, you should disclose. Many of them are happy to help where they can. All right, let's see. So what happens when the advocate can't get it done? This is what I call the nuclear option. A referral to an attorney is a pretty serious thing because it costs a lot of money and it's a serious undertaking. I want to make sure that anybody you get referred to at this point would be a special education attorney. It's not really appropriate for a family law kind of person or a general attorney, tort lawyer. None of these people would be appropriate to represent you. You really need a special education attorney. They're going to repeat the whole record review process, and they may need to request additional records. They may tell you you need additional testing. They're going to take a much more serious tone about the paper trail. The cost of an attorney, a retainer for representation usually starts at around $2,000, somewhere between $2,000 and $10,000, depending on how serious things have gotten by the time you get there and just their general rules of practice. Everybody's a little different. Their hourly rates range from $200 to $325 an hour. They also do occasionally offer pro bono or sliding scale services, and you should ask if that's something that you would need. When you hire an attorney, if they decide to take your case and it becomes something that's actually going to go to hearing, there's usually an additional retainer to file for that hearing because that's when the process gets really big. So just by way of having you be informed, this nuclear option is quite costly and quite stressful, and you really should try to exhaust every other option before you go this route. So I wanted to share a couple of outcomes with you. Most people who have hired an attorney because they cannot, find a solution to their disagreement with special education will settle out of court when represented by an attorney. Many of them settle at what's called the pre-trial conference, which is just to sit down and talk about the trial before the hearing actually begins. If you get to that point, sometimes those will be settled. There's a decision after the due process hearing is completed, and I'm going to share with you some of the outcomes just to give you a little bit of, to share the impact actually. So in a longitudinal study of special ed by William and Vivian Blackwell, cases filed up to 2013, and this may have been updated, but I suspect the numbers will look similar. There were 258 special education cases filed. 142 of those were won by district with legal representation. So the school prevailed in 142 of the 258. 32 cases won and 21 mixed decisions were rendered to parents with legal representation. Of the 258, 32 were won by the parent with representation. 8 were won by parents pro se, which means that they went in by themselves, no legal representation. And 2 won entirely pro se, no advocate. So you can see that as you get further away from legal representation, the likelihood of you prevailing becomes less. So you do not want to go to a hearing without an attorney. I certainly hope you don't need to go to a hearing at all. But I'm happy to have had this time to share with you sort of the way that works. So the moral of the story is the burden of proof falls on you, and you should enter into any legal proceeding with great caution and always with an attorney. Here's a couple of the resources that I referenced, all very, very useful in dealing with asking questions, finding advocates, looking for lawyers, and many other things. So I hope that this was informative. Find me on my website,